back on the record after a mid-morning break, ready to resume with cross of this witness.
Yes, Your Honor. Good morning, Dr. Young.
Good morning.
Just given that we're getting near lunch, we'll just jump straight into it if you don't mind. At least concerning your experience, you yourself in conducting autopsies, you've never seen a case of child strangulation, correct?
I don't recall a case of child strangulation, no.
And even in the autopsies you have conducted, child hangings are rare, correct?
Yes.
I believe in prior conversations about your past, you've noted that you did do one autopsy of a child who hung themselves off of a bunk post or bed bunk post with a belt. Is that correct?
Yes.
And that would be essentially the extent of your autopsies of children with those types of strangulations.
There may be possibly one or two others, but that was one that I specifically remembered. It was, interestingly enough, the child of a psychiatrist.
Fortunate. Now, at least as far as strangulation, you've noted in the past that you typically see evidence of a struggle, correct?
In strangulation cases, yes.
So that would be evidence of head injury, for instance.
Sure.
Hemorrhages in association with broken bones and cartilage in the neck.
Yes.
And as far as the literature relating to forensic pathology, you're not aware of any distinctions from a medical standpoint between a child hanging victim and how they present versus an adult hanging victim and how they present.
Okay, I'm not sure I understand your question.
Are you aware, in any of the literature you've reviewed in the past or textbooks, of any distinctions made in that literature, medically, between how a child hanging victim presents in terms of injury, artifact, whatever, versus an adult hanging victim?
Okay, I'm not aware of it.
As far as any of the literature you're familiar with, you're not aware of people that are near death staring in some way, shape, or fashion, correct?
Well, there's different kinds of references to things like the 1,000-mile stare and all kinds of things having to do with a variety of things. But I'm not really sure that I recall anything of the specific nature that you're talking about.
And in fact, when asked in the past about folks nearing death having some form of staring, you've noted that that's kind of weird as a descriptor, correct?
Well, as a stare, yeah.
And that it's not scientific to describe it that way.
Well, somebody basically has had their eyes open and the eyes are facing forward. You don't really know that that's a stare. A stare is something where you're actively looking at somebody intently.
So, if you were to look over testimony that indicated that a child's eyes, just looked forward right before death, you'd not categorize that as a stare?
Well, I don't know.
Does the literature indicate that someone before death, during a strangulation, asphyxiation, hanging, would stare forward or at least look forward?
I'm not aware of reading anything like that.
And you said you're not aware of any in the literature?
I'm not aware of reading anything like that.
Now, you're familiar with the textbook of Spitz and Fisher, correct?
Yes.
And by the textbook, I just mean it's a bit of a mouthful, the medical legal examination of death or something to that effect.
Sure.
And you've previously described that textbook as usually put in the list of seminal texts relating to forensic pathology.
Sure.
Now, I'm just going to go through different parts of the book that they reference, and all you need to let me know is whether that sounds correct coming from Spitz and Fisher, as in that would be a correct summation of their position. when a twisted piece of clothing or a soft blanket is used, there may be no mark at all on the skin.
Sure.
The amount of pressure on the neck that can bring about loss of consciousness is remarkably low.
Well, it depends on what you're remarking.
To be more specific, it's said that 5 or 6 pounds of pressure per square inch suffice to block the carotid arteries and jugular veins, which would lead to unconsciousness.
Sure.
And then they also note that 32 pounds is all that's required at most to block the airway.
Sure. This is in reference to an article many, many years ago in the Journal of Forensic Sciences, where they actually looked at that.
As far as their description of hanging, they've noted that injuries to strap muscles in the neck are very rare for hanging, correct?
Well, I'd agree with that. In hanging cases, you usually don't see anything like that.
The tongue frequently protrudes from the mouth of a hanging victim.
Yes.
And then they also note that, as a point of interest, the degree of calcification of neck structures tends to vary with age, correct?
Sure.
So in older individuals, for instance, the C-bone that you've referenced in direct, the hyoid bone, thyroid and cricoid cartilage, they become rigid and unyielding with age.
Well, they get more calcified.
And essentially, that by unyielding, I presume Spitz and Fisher means are more brittle. Would that be?
I'm not sure what they mean by unyielding.
They follow that by saying that when pressure is applied to the neck of an elderly person, those structures tend to break significantly more easily than in a young individual.
That's I recall reading that, yes.
And they note that the phenomena of calcification is well established, so it's not uncommon to find a child or young adult with no fractures of any of these structures, even in cases of strangulation.
Okay.
Does that jive with what you've understood when reading Spitz and Fisher and relying on that seminal textbook?
It makes sense. I mean, yeah, if there's not a lot of calcification and the structures are pliable, it might resist it breaking, yes.
Now, you've noted that you're not aware of distinctions from a medical standpoint between child hanging victims and adult hanging victims. Would that calcification, just now that we've gone over it, essentially count as a differentiation between how both present from a strangulation or hanging?
Usually with hanging deaths, there aren't any fractures of any bones in the neck. And, yeah, hanging, usually the person is basically applying pressure to the neck in a way that they can control. Now, in a strangulation, there may be strangulations in which there aren't any fractures, and then there may be strangulations in which there are fractures. This is not something that the victim is able to control, but in a hanging, there typically isn't any fracture.
You've noted that Dr. Catalier's findings are not supported by materials in the literature, correct?
Okay, that's not quite what I'm saying, all right? What I did say about the literature is that you can learn from the literature what's possible and even what's common. But applying the literature to a specific case is problematic because a lot of times the case reports are with circumstances that are completely different than what is in the specific case in question.
And we'll get into what it is, but that seems to build off of something you've written about before, the inferential test, correct?
No, that's not something that I've referred to. I'm just telling you that right now.
Going to what you have written in the past, you have written in 2009 the inferential test for expert testimony, correct?
Yes.
You wrote putting it all together, the logic behind the forensic scientific method and the inferential test.
Yes, sir.
And at least going off of one of your answers during direct, as well as prior testimony, you've noted that Catalier must be imagining a strangulation in part because no one observed the strangulation.
Right?
No, you've noted no witnesses describing a strangulation.
Right.
And so would it be fair to say, at least in your opinion, that a strangulation scenario where there is no one that saw the strangulation take place, it's just not a reliable scenario, it's not tested reliably?
Okay, I'm not clear what you're asking.
I'm just asking if you agree with the statement, a strangulation scenario where no one saw that strangulation take place. Such a scenario is not a reliable, I guess, opinion on the matter in this case.
I would agree with that.
Would you agree that the fundamental problem that you find with Dr. Cavalier is that she's attempting to determine a past event through an autopsy?
Yes.
You find that method unreliable?
Yes.
And
Unreliable for certainty.
And as far as
If you want to posit as a possibility to investigate, holding that up as a hypothesis, that's legitimate. But to state something categorically and certainly on something that is theoretical is not reliable, especially when it comes to past events, which are very complicated.
going to your inferential test, I'll try to note what it is, and you can agree with me if it's a correct recitation of your test. One can be reasonably certain if witness accounts of the past are consistent or not consistent with physical evidence in the present. But one cannot reliably surmise past events from physical evidence unless there's only one plausible explanation for that evidence.
Yes, sir.
So the ultimate problem that you find with Dr. Cavalier is that she's violating this inferential test you've created.
Well, if she is claiming to be certain about something that she is surmising, that's problematic. According to that second part of the inferential test, one cannot reliably surmise past events from physical evidence. Claiming to be certain on something that is unreliable is not good.
And in truth, you actually wrote an article entitled, or possibly a chapter, noted that the inferential test is always true, and we should think of it as a law.
Yes, sir.
Now, you wrote about this law in 2009. Since then, what peer-reviewed forensic pathology studies or articles cite to this inferential test?
None that I can think of.
And if you could note, are there any forensic pathologists that have published studies testing your inferential test?
No?
Now, you've previously also written a thesis entitled Dr. Young Addresses the Big Question on October 6, 2011. Is that correct as to date?
Yes, sir.
And if I may, I just wish to read a section of the introduction, and you can confirm if it's your writing. Much has been written on the topic of origins. How did the universe and life on this planet begin is indeed the big question. Scientists and other intellectuals have answers, but none of these people appears to have a corner on answers that are demonstrably truthful. Most scientists in academic settings believe and teach Darwinian or non-Darwinian evolution and the Big Bang Theory. I apologize.
Start with Darwinian.
Darwinian. Darwinian or neo-Darwinian evolution and the Big Bang Theory. A few others invoke intelligent design as a scientific explanation. And even fewer scientists believe that science points to a creator God who formed the heavens and the earth as described in the book of Genesis in the Bible. So many theories, but what is the correct answer? Ladies and gentlemen, in the next several chapters of this small treatise, I will do something that no one, to my knowledge, has ever claimed to do. I will prove to you beyond a reasonable doubt that the God of Abraham created the heavens and earth in 6 literal days. Is that a correct summation of your writing in that chapter?
Well, it's word for word, yes.
Shortly thereafter, you note that the purpose of the treatise is to demonstrate the power of your inferential test for expert testimony. Is that correct?
Yes, sir.
You also note that this treatise is not a religious treatise. It's essentially a symbolic logic and scientific treatise. though I may be adding the second part, you do note it's not a religious treatise.
I do.
On page 9 of this treatise, you note that the scientific method does not work for past events.
Correct.
You note that the past is not observable by scientists living in the present.
Correct.
You note that scientists cannot perform experiments on the past.
That's right, because they no longer exist.
So one cannot claim to be an expert on past events as a scientist if he or she was not there to observe it, measure it, or manipulate it for purposes of proof.
Sure.
You've also written that scientists who all agree on past events they have never seen offer an appeal to false authority, which is a fallacy.
Right.
You note that one cannot claim to be an expert on a past event as a scientist if he or she was not there to observe it.
Right.
On page 10, you note that in your forensic practice, you do find that witnesses provide past event explanations for physical evidence that have greater explanatory power than the scenarios invented by scientists.
Yes, sir.
And then on page 13, you note that the scientific method as it is does not work for past events, and that this method's failure is why forensic pathologists and child abuse pediatricians infer improperly, which leads to false accusations of child abuse, strangulation, and other crimes.
Yes, sir.
You then further note that paleontologists, geologists, and evolutionary biologists apply science to past events, and just like forensic scientists, they essentially are applying science to past events, which is wrong.
Correct.
So of significance in your disagreement with Dr. Catalier, the fact that she is trying to extrapolate her findings from an autopsy when there is no witness that saw strangulation, much like your description of the scientific method, that's incorrect to try to apply the scientific method she has to past events.
Fair.
And at least, would it be fair to say that through this treatise you're noting that scientists should not apply the scientific method as they do to past events?
Not the standard scientific method. There has to be an adjustment in order for it to be logically valid. There has to be a different approach.
And you've written about that different approach, and I believe named it the forensic scientific method, correct?
Yes, sir.
At least as to the forensic scientific method, what forensic pathologists have cited to your description of it in any published peer-reviewed literature?
Okay, please repeat the question.
Yes. Concerning the forensic scientific method, as you've written about it, can you cite a forensic pathologist that has written about it in published peer-reviewed literature?
Okay, I'm not aware of anything.
Now, we previously discussed at the prior trial of this case about the Jessica Harper case. Is it okay if I just assume you know what I'm talking about?
Yes, sir.
Now, at least in that case, that was, I think, sometime back in 2005 or 6, give or take. Is that
Yes,
about
sir.
right? In that case, prior to you, a defense pathologist in the case had agreed with the state pathologist. Is that correct?
I'm sorry?
In that case, Jessica Harper's case, before you became involved, is it your understanding that the previously retained defense pathologist agreed with the state pathologist?
Your Honor, at this time, I'm going to object to the line of questioning overall as for relevance.
Objection sustained on relevance.
You've claimed in the past that no one had ever asked you to resign from your position as chief medical examiner, correct?
Correct.
In fact, you declared in front of the jury in this case that no one had ever asked you to resign, correct?
Correct.
When you were shown an appellate court decision that seemed to be under that impression, you noted that that was a misstatement of fact by that appellate court, correct?
If they made such a statement, that would be a misstatement of fact.
And by saying that no one has ever asked you to resign, you would be saying that, for instance, no prosecutors ever provided a letter to the medical examiner's office asking for you to resign.
None that I've ever seen.
As far as your testimony, that you noted that the appellate court got wrong on that issue, would it help refresh
Your Honor.
He hasn't completed the question, so I didn't hear it. You can go ahead and complete, well, actually start over.
Yes, Your Honor.
With your question.
So under oath, you had noted that no one had ever requested your resignation, correct?
Correct.
Would it help refresh your recollection to review a transcript of a prior trial where you note that?
I
Your
don't
Honor,
know.
I'm going to object. I'm not certain as to the relevance of Dr. Young's position that he's never been asked to resign as a forensic pathologist, how that is relevant to his opinion as outlined in this case.
Your Honor, if I may.
An objection overruled. His credentials and credibility is at stake, so go ahead.
Do you remember the question, or should I repeat?
You want me to review something?
Yes. Approach the witness.
Okay.
Review pages 70, specifically maybe from line 15 till about the next page, page 71. Once you're done reviewing that, if you could let me know.
Yes, sir.
Going to an exchange you had with the prosecutor in this case back in 2011. Isn't it true that you noted to that prosecutor that you had seen a letter signed by 6 prosecutors?
There was a letter that was signed by 6 prosecutors. The letter specifically stated that they didn't want Dr. Thomas Gill, who at that time was the deputy medical examiner, to perform autopsies on any of their homicide cases. That's what the letter talked about. It didn't talk about Young resigning.
So, when you were asked, wasn't it true that there were 6 prosecutors in the area who had written letters to the county executive and other people that we need to get rid of Tom Young as a medical examiner because we can't rely on his opinions? And you said, do you want to hear the story? And then you were pressured again, whether it was a true or not statement, and you noted that you did see their letter. But you failed to note that it was not about yourself, but Thomas Gill. You're saying that even though you didn't mention it under oath in this trial, it was about Thomas Gill and not yourself.
Okay, there's only one letter that I am aware of. I have a copy of it in my home office. It basically is requesting Dr. Thomas Gill not to do any of their homicide cases. It was instead requesting that I do the homicide cases. They're not asking for me to resign when they want me to do their homicide cases.
And this was specifically in the context of discussing the concerns of those prosecutors after a judge found you to not be credible in Ms. Harbor's case. Is it not true?
Okay, I don't recall what the context was. Okay. There was a judge that did make a statement that he did not find my testimony to be credible, and for that reason he went ahead and accepted a no contest plea offered initially by Jessica Harbour and waived her trial. But he used that basically as the justification for doing the no contest and not having a trial.
So even though the context of this discussion with this prosecutor was that prosecutors were concerned about your credibility, you're saying the letter was not in regards to you, it was in regards to Thomas Gill?
Yes, sir.
You noted that you have never been censured in the past, correct?
Yes, sir.
Would, in your eyes, having your testimony excluded by a district court and confirmed by the Kansas Supreme Court because of credibility issues with your failure to follow the scientific method not count as a censure?
No, sir.
So when courts have excluded your testimony in the past out of concerns that you don't follow the scientific method, you're saying that's not a censure?
That's not a censure. The censure is basically when your license is being called into question and the body is trying to decide whether or not you get to continue to practice medicine in the state. Okay? If a judge has an opinion that he or she doesn't want me to testify on a particular case, that's an opinion. And that on occasion has happened. But that's not a censure.
And just to confirm, as applying the scientific method by a forensic pathologist to past events, you do not believe that method is correct?
Applying the scientific method to past events doesn't work. This is demonstrably in using statement logic in any kind of sort of logical sort of situation. If part of the scientific method involves a scientist observing something and then experimenting on what they've observed, this requires the manipulation of items in the present that can be observed, that can be manipulated. Things that have happened in the past no longer exist, cannot be observed, at least by scientists, and cannot be manipulated for the purposes of demonstrating anything. And so the scientific method is problematic when applied to past events.
So forensic pathologists that rely on the scientific method in reviewing a past event that does not have witnesses saying, for instance, where they're believing that the evidence of the autopsy shows a strangulation, but there's no witness to strangulation, you're saying that trying to use the scientific method in that situation is highly problematic?
Sure.
Same would apply for geologists or anyone else reviewing past events, such as you discuss in your treatise on the essentially creation of the world.
There have been all kinds of geologists that have come up with all kinds of theories, and some of them very, very detailed. And many of them are prehistoric. These are all largely speculative because they don't have anybody who's witnessed any of these things. They have invented basically theories and used whatever evidence they can to support whatever they're imagining. This doesn't work in court cases. It doesn't work in forensic science situations and in this sort of thing where you basically look at evidence and then imagine something and then find evidence to support what you imagine. This is problematic logically, and I've spent a lot of time through truth tables, through logical proofs to demonstrate that the thing is not valid to do that kind of thing.
And have your truth tables and logic work been accepted by the general forensic pathologist community in published articles, peer-reviewed published articles?
Okay, they don't acknowledge it, they don't recognize it, they don't talk about it. And I haven't submitted that to any forensic pathology journal. I have a hunch that if I did, they wouldn't like it.
May I have a moment, Your Honor? Pass the witness, Your Honor. Thank you, Your Honor.
Doctor, you were asked a question about staring and whether or not that was unusual or an observation you would expect in a scenario such as this. Do you recall that question?
Yes.
The fact is, dead people don't stare. Is that true?
Right.
And is that part of why that question is sort of, or why you take issue with that question is because the term stare is being misused?
Sure. Staring is something that is an active thing that is done by a living person. Okay, when they're focusing their gaze on a particular item, that's a stare. If you simply have a dead body that has the eyelids open and the eyes are looking forward, but there's no active mental thing going on, that's not a stare.
You were asked questions about case reports, and the case reports that the state was referring to, those are largely anecdotal, correct?
Okay, I don't know. I don't know
Okay. Would there be, if a case study looks at an individual case, is it fair to say that the findings in that individual case should be the same in other cases involving the similar circumstances?
Okay, findings and publications of an individual case are a case report. The case report has specific circumstances, specific items that are basically unique to that case. Applying items that are unique to a particular case and applying them wholesale to another case which also has unique circumstances is problematic.
You were asked about a letter that was sent from 6 prosecutors. You recall that testimony?
Yes, sir.
The testimony you provided today regarding that letter was the same testimony you provided previously to this court regarding that letter. Isn't that true?
Yes, sir.
Objection bolstering.
Sustained.
And you're appearing in court today to provide testimony as an expert in forensic pathology, correct?
Yes, sir.
How many times have you done that before?
Well, this is number 500. This is my 500th testimony today.
So on 499 previous occasions, you've provided expert testimony in the area of forensic pathology to a court of law as you are here today.
Yes, sir.
And correct me if I'm incorrect, but on 3 prior occasions you were asked not to testify. Is that correct?
Yes, sir.
One of those was a military case. Is that correct?
Involving military person, yes.
Was that the reason for your exclusion in that case?
No.
Why in that case?
This was State of Kansas versus Christopher Lyman. The judge there in the Geary County Court side items such as Dr. Young addresses the big question, questioning whether or not what I did was scientific.
In 2 other cases in which you were excluded, is it not true that the court determined that your testimony just wasn't helpful for either side?
Okay, one other case this was in the same Geary County courthouse. The judge didn't want me to testify because he didn't think that it was relevant or helpful to the case. And this was not involving anything else. Then there's another case in Shawnee County, which is the county next door in Topeka, Kansas, in which it was another child abuse case. And I'm not really sure what the specifics were in the judge's opinion on that.
So the 500 times you've testified at trial, 3 times they were excluded, twice in the same county, and then 1 other time in the county next to that same county, correct?
Yes, sir.
And that's in your entire career as a forensic pathologist?
Yes, sir.
Dr. Young, would you ever jeopardize your ethics for the purpose of monetary gain?
Objection, bolstering.
Objection overruled. Witness can answer.
No, sir.
Earlier, you had testified that you contracted with the defense team for Kelsie Thomas to provide services, but we're not paying for an opinion. Is that correct?
Correct.
So, Dr. Young, we've gotten into, I guess, more theory than maybe is necessary, but in this case, if there is an attempt to determine past events when there's an explanation that's consistent with the findings that the witnesses had put forward, is that problematic?
Sure. I mean, one can be reasonably certain if witness accounts of the past are consistent or not consistent with physical evidence in the present. This is a deductive inference, okay, where you're basically supplied information as to what was seen in the past, comparing it for consistency or inconsistency with physical evidence that scientists observe in the present. This is a deductive inference. Taking autopsy findings or physical evidence and building a scenario, something that happened in the past, is an unsubstantiated hypothesis. Okay, you could even call it a theory because it's a hypothesis with multiple parts. It's basically making past events out of whole cloth. Such a thing is not reliable any more than it is reliable to basically come up with the winning lottery number or to be able to reasonably guess a password on a complex computer password. There are many, many things that can lead to the same set of physical evidence. So claiming that you know what happened in the past in such a situation is not reliable. It's a hypothesis that is not supported.
And as your expert opinion would have confirmed a hanging in this case, you're looking at known facts, whether that's witness statements, and in this case you didn't rely just on Kelsie Thomas, you also relied on the EMT workers and other witness statements, correct?
Yes.
And then compared those to the findings at autopsy, correct?
Yes, sir.
And is it accurate to say that in your view, Dr. Cavalier took those findings and then invented a scenario, one of many scenarios that could fit those findings, but she invented a scenario that supported a manual strangulation where she has no reasonable ability to ascertain those things?
Fair.
No further questions, Your Honor.
Recess.
So just to piggyback on that last question, Dr. Young, you're saying Dr. Cavalier, by finding a strangulation through manual ligature and some hanging evidence or presentations of those three forms of strangulation, that's an invention of hers.
Okay, I didn't understand your question.
With Dr. Cavalier finding that strangulation occurred with a mix of manual, ligature, and hanging, you're saying that that's an invention of hers that she's created whole cloth from her autopsy as opposed to relying on witness accounts.
Okay, I just heard something new here, that basically Dr. Cavalier has three things that she thinks had happened. That there's a manual strangulation, a ligature strangulation, and a hanging. Is this what you're saying? Because this is new to me.
The autopsy report just noted strangulation, correct? It did not note that manual strangulation was the only finding as a cause of death, correct?
Okay, I'd have to review the notes again.
If you could take time to review your notes.
She has in her outline evidence of evidence consistent with ligature strangulation. She says evidence of suspension, and then she puts down the cause of death as strangulation. Okay, I don't see anything in her autopsy reports about manual strangulation.
But it is essentially your testimony that Dr. Cavalier got it wrong by applying the scientific method to past events that were not observed the way she finds that they were observed.
I think that's fair.
And going to the Lyman case that you referenced earlier, in that case, I believe you're quoted as also saying that that pathologist is essentially, it was their invention of what they were finding from their autopsy there as well.
Okay, I don't recall. It's available online if you want to review it. The judge writes their opinion. I don't recall exactly what the judge says. He addresses several issues.
Let me ask it this way. This is not the first time you've believed a pathologist essentially invented a scenario that was not confirmed by witness accounts.
Fair.
And that's essentially the same invention that paleontologists, geologists, and evolutionary biologists do when they try to figure out past events that they did not witness.
Yeah, they're theorizing.
Nothing further, Your Honor.
Anything further for this witness?
No further questions, Your Honor.
You may step down. May this witness be excused?
You may.
You may also be excused and leave the courtroom.
Thank you.
Other evidence, Mr. Cook.
Your Honor, the defense rests.
Defense rest.
Sorry, Your Honor, I didn't mean to talk on the record. I was just discussing the colloquy with the defense on that issue as to resting and whatnot.
Rebuttal evidence.
Oh. No, Your Honor, State does not wish to present any.
No rebuttal evidence. So the evidence is essentially closed, except I don't think that I have Exhibit 111 yet, the stipulation between the parties. Was it just uploaded?
I'm sorry, Your Honor. I just didn't file it yet because I know you said that there was some issue with the numbers, so I wanted to be able to talk about that first. Or I could file it and then we could correct it if we need to, whatever you prefer.
Off the record. '91 through 111.
Yes, Your Honor.
Yes, Your Honor.
Okay. Are you ready, Carrie? Back on the record. The state has offered, I believe by stipulation, State's Exhibits 91 through 111 to be considered by the court in this case. Is that correct?
Yes, Your Honor.
Any
Yes, Your
objection? Okay. State's Exhibits 91 through 111 are received by the court. Off the record. Carrie, are you satisfied that we have everything? Okay. Then I guess I need to put the deadline for the parties' briefs on the record. And that was November 3rd. Back on the record, the court has discussed with counsel, and I believe counsel have agreed that arguments will be done in writing, and that both counsel will submit their written briefs to the court by November 3rd, 2020. And that will be by midnight. by EDMS rules. And if, you know, if you, for some reason you need more time, let me know. But that would be the court's rule as of now, is that both parties are going to have their briefs done by midnight, November 3rd. Is that acceptable to you, Mr. Neff?
Yes, Your Honor.
And to you, Mr. Cook?
It is, Your Honor.
Off the record. Questions about?
Well, I could certainly do that if you want me to, Judge. We
Okay.
just need to make a record on it.
Okay. Back on the record. We're back on the record. The court's informed that defense counsel wishes to question his own client with respect to her decision not to testify in this case. Go ahead, Mr. Cook.
Thank you, Your Honor. Ms. Thomas, prior to trial, Nicole Jensen and I discussed with you how this trial was going to go. We also discussed with you the possibility that you may be able to provide your own testimony to support your defense, correct?
Yes.
And in the context of those discussions, and in fact, in getting prepared for some of that, ultimately, you decided that you did not want to provide testimony in this case, correct?
Yes.
And that was your choice that you made freely, intelligently, and without any threats or duress or coercion from your defense team, correct?
Yes.
All right. Anything else then that needs to be put on the record in this case? Mr. Neff?
I don't believe so. I will address it with defense counsel and then, Your Honor, if there is anything that arises, but I'm pretty sure we've gone through everything.
Mr. Cook?
I don't believe there's anything else, Your Honor.
The record is closed. Thank you all for coming. I will issue a written decision, of course, waiting for counsel's briefs in the matter. That completes the record.
Do we have a page limit, Judge?
Mr. Cook, you may write to your heart's content. I do like Russian novels.
Try to keep it readable without reading. Kelsey will let you know.
Yeah. She might not know.
Yeah, I'm thinking maybe just to keep it away from all the other players, put it in your office.
Do I have to send some? Yeah, it's just printing, I don't know, there's like 5 pages. I'm just putting some.